Okay, Shannon, you can put us on, please.
Okay.
Good morning. This is a matter of Lucas Franstead. I'm going to ask each of the attorneys to state their appearance, please.
Kelly Tucker here on behalf of the agency.
Kelly Guardian ad litem.
Ivan Darlin on behalf of Stacy Franstead.
Ken Hotchkiss on behalf of Travis Shaw.
Okay, and Ms. Franstead and Mr. Shaw are both present?
Yes.
Mr. Shaw, can you hear me?
Yes, sir.
Okay, and let's see. And we have Aaron Geyer and Jacqueline Geyer on behalf of the agency, and I think that's everybody. Okay, we had a conversation informally off the record among the attorneys. My understanding is that although the parties signed an affidavit of parentage, apparently it got rejected by the state, probably because something was crossed off on it. They won't accept those. What I'm hoping to do, I'm assuming you're both still willing to sign an affidavit, if you could get that to the agency rather than sending it in yourself and let them take care of filing it, or did you already fix this?
I already fixed it and mailed it back in, Your Honor.
Okay, did you keep a copy of what you mailed in?
I did not.
All right, so we're gonna have to wait until we get that back before I can take any formal steps as to Mr. Shaw. He would still be considered putative until we get confirmation that the affidavit's been filed. But my understanding, Mr. Darling, is that the mother is prepared to enter a no contest plea this morning.
Yes, Your Honor.
Can I ask you to tell me the reason for a no contest plea?
Liability.
And Kelly, do we have anything for a factual basis?
Aaron or Jacqueline, do you have like a 154 you could send to me quickly? Like an investigation of some kind?
If not, I could just take some brief testimony from whichever worker has the knowledge of the underlying allegations.
That would be me, Your Honor.
Okay. Well, in the meantime, I'm going to move forward with the plea. So, Ms. Franstead, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down now. I'm going to ask you to state your full name for the record.
Stacy Reed Franstead.
Ms. Franstead, you are the mother of Lucas Franstead, born April 26th of 2020?
Yes, Your Honor.
And was Lucas found in the county of Jackson at the time the petition was filed?
No, Your Honor.
Where was he?
Calhoun County.
But was his residence in Jackson County?
Yes, Your Honor.
Have you read the petition and do you understand the allegations that are made in it?
Yes, I do.
If the court accepts your plea today, there will not be a trial, and you would be giving up the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand
I do.
that you'll be giving up these rights if I accept your plea today?
Yes, I do.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your child a temporary ward of the court, place him with either parent, with relatives, or in foster care, and order services and programs designed to solve the problems. If the court determines you are unable to provide your child with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. You understand each of these consequences.
Yes, I do.
If your parental rights are later terminated, your obligation to support your child will continue until a court modifies or terminates that obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
No, Your Honor.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No, Your Honor.
Are you entering this no contest plea of your own free will?
Yes.
And do you understand that I will treat your plea the same as I would an admission of responsibility?
Yes, I do.
Okay, and Callie, you want me to swear Ms. Jacqueline Geyer?
Sure, that would be great, Your Honor.
Ms. Geyer, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down, state your full name for the record.
Jacqueline Geyer.
Go ahead, Ms. Tucker.
Thank you. Ms. Geyer, you are employed with the Department of Health and Human Services,
That's correct.
and it's through that capacity you became involved in the case of Lucas Franstead, a minor child whose residence is here in Jackson County.
Correct.
Is it you who drafted the petition for Lucas Franstead?
Yes, I did.
Okay, and so therefore you're aware that Stacy Franstead, date of birth, October 6, 1986, is a respondent in that case?
That's correct.
Can you tell me how Lucas came to the attention of DHHS and why Stacy was made a respondent?
Yes, I received a complaint, a CPS complaint on January 31st, stating that there was an incident of domestic violence that occurred between Stacy Franstead and Travis Shaw. The complaint stated that Mr. Shaw was under the influence of methamphetamine. It stated that Lucas Franstead was asleep in the other room when Miss Franstead was assaulted by Mr. Shaw. So CPS was had to get involved for an investigation. I safety planned with Miss Shaw, or I'm sorry, Miss Franstead, that she would keep Lucas in her care and that he could not be around Mr. Shaw. The safety plan, it was brought to my attention that the safety plan was broken. CPS was made aware that Lucas was at the residence of Mr. Shaw. So CPS had to remove Lucas from the home.
Thank you. Did you ever speak to Ms. Franstad about the assault itself?
I did.
And was her account consistent, at least with the initial referral made?
Yes, it was.
Okay. And did she also confirm that Lucas was in the home when this assault took place?
Yes, she did.
Okay. Did she have any injuries from the assault?
She reported to me that both of her wrists were broken. I did observe two, can't think of the word, two braces on each wrist.
Okay, thank you. I just wanted to get an idea of the assault itself.
Sure.
And then you mentioned the safety plan had been violated. Did you ever talk to Ms. Franstad about that?
I did.
Did she make any admissions that the child was left in the care of Mr. Shaw?
She did not.
Okay. Is there any other concerns regarding Ms. Franstad that we did not cover as it relates to Lucas?
No.
Okay, thank you. I have nothing further.
Thank you.
Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made. I find that the record supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared to move forward with disposition as to mom this morning?
Erin, would you have recommendations ready for the court today?
I have a case service plan that we've already established, so I could go off of that, yes.
Okay, thank you. I'm fine with moving forward with disposition then, Your Honor.
Okay, I do have a parent agency treatment plan in the file. Let me well, it looks like the recommendations are kind of scattered through the plan. I was hoping they were all compiled in one place.
If you'd like me to testify, Your Honor, on my program, they're all in one place, so I could speak to them
Oh, okay.
a little more succinctly.
Go ahead. Tell us what your recommended, what your recommendations are.
Just give me one moment. So we've put services, or I've recommended services with Stacy and Travis. For Travis, the services that have been, he's been referred to are parenting classes through the Women's Co-op in Calhoun County, domestic violence classes for perpetrators through the Women's Co-op in Calhoun County. He has been signed up for random drug screening through AverHealth, and he has a psychological evaluation scheduled. I do not recall the date of that off the top of my head, but it is scheduled. For Stacy, we are recommending drug screens through AverHealth as well, domestic relations, counseling, and parenting classes. She is doing both of those in Jackson. She's also been referred to housing resources so that she can secure her own housing, and a psychological evaluation has been scheduled for her as well.
Okay, as to Mr. Shaw, since we are not able to do disposition as to him, I think it's good if he's voluntarily participating in these things, but I can't order them yet as to him. But I can as to Ms. Franstad. Mr. Darling, do you wish to be heard about any of the recommendations?
No, I would just like to put it on the record that my client has already started following the plan and is already in progress with the services.
Very good. I'm glad to hear that. We will enter an order of disposition as well today then with those specific services for mom. I'm going to adjourn the pretrial for 2 weeks as to Mr. Shaw. Hopefully we'll have an affidavit of parentage back by then, and we can proceed as to his part of the case. So that will be May.
So I'm doing Dad first.
Yeah, well, I don't care the order, but we need a pretrial date for Dad.
So 2 weeks, May 11th.
May 11th at 8:30. And then dispositional review hearing for Mom on
The 25th at 8:45.
of
May.
just a month? Should it be 3 months?
Oh, yeah, we just did. Hang on. So, July 20th at 9.
July 20 at 9 a.m. All right, anything further on this case?
No, Your
Your Honor,
Honor.
I would just indicate, if I may, to my client, Mr. Shaw, I did try to call you and left a message. If you could give me a call at your convenience so we can discuss how you'd like to proceed, I'd appreciate it. Thank you.
Okay, Ms. Franstead, I wish you well. I'm glad you're on board already with services. I do want to say, I usually will say this to moms and dads when the underlying issues involve domestic violence. Even if you aren't as concerned for your own safety, I just want to impress upon you how damaging it is to a child to be exposed to domestic violence. And I want you to remember that. I want you, no matter what, to make sure you protect Lucas from ever being exposed to any kind of domestic violence. Kids are hardwired by their creator to believe that their parents are good. And they can't process when a parent behaves badly. They just, often they will tend to internalize that. They will tend to blame themselves. Now, I realize Lucas is pretty young, but as he gets older, he's going to struggle with this. So I just strongly encourage you, for his sake, to stay the course here. I wish you well.
Thank you, Your Honor.
Okay, let's see. Let's move on to the Lewis minors. Shannon, do you have a sticky note? Mike, was it you that asked for a copy of the psych eval in this case for Mom?
I did, and I think Rebecca wanted her clients as well.
Actually, I do have mine.
Same time.
Still.
Oh, do you still have it? Okay. Yeah, then just me.
All right.
Thank you.
Okay, so let me get everyone in here. All right, I don't see either parent logged in by name. I do have a couple of devices here. Let me see who they are. So I just let in a telephone ending in 5906. Could you tell me your name, please?
Kenneth Cox.
Okay, Mr. Cox, I'm going to put a name on your screen so I know who you are, and I'm going to put you back in the waiting room. This way I'll know to bring you back in when it's time to call your case.
All righty, thank you.
And let's see, I've got an iPhone. Let me see who that is. Does anyone recognize her?
I don't see a picture, Judge.
Oh, okay. All right, looks like we just made a connection. Ma'am, what is your name?
Kristen McKay.
Boy. Sorry, I wasn't able to make that out. It broke up. Say your name again.
Kristen McKay.
Okay, that was better. All right, Ms. McKay, I'm going to put you back in the waiting room till it's time to call your case.
Thank you.
And let's see. I do not see. I've got one other device with a first name of Devin. It doesn't look like we have a Devin on this case, but sometimes they call with partners' devices or kids' devices.
Or that's probably Devin Lemble, which is the dominant toll matter.
Oh, okay. All right. So it looks like the parents aren't here. This is the matter of the Lewis minors. Kelly Tucker for the petitioner. Mr. Brown is LGAL. Mr. Kelly represents the mother. Ms. McCluskey represents the father. We had a fairly lengthy conversation off the record about the request for permanent jurisdiction and the need, if we're going to go forward on a termination petition, for the parents to get an independent evaluation done. We usually use Dr. Girton for this. Is he acceptable, Mr. Kelly and Ms. McCluskey?
Yes,
Your Honor.
Ms. McCluskey, would you be able to and willing to make the arrangements with Dr. Girton?
I sure can.
All right, and apparently these are fairly fresh allegations, so we probably don't have all the medicals yet. Is that accurate?
I looked back through the discovery I sent yesterday. It appears we have everything from Dr. Moore in that regard. Ms. Peters, did you request any medical records from any other hospitals or treatment providers?
No, and I can do that today. I just spoke with the PA that had examined Remington that night, the night of the removal, and the marks were observed. I just don't have the actual records. I can request them and get them by the end of this week. They're fairly quick at Henry Ford.
Great. Okay.
So does it make sense for me to adjourn the pretrial for, excuse me, for a couple weeks to see where we are?
I think so, Your Honor. I'll continue to work with the agency both on medical records and just discussing this case in general. And we can check back in with everyone at that time.
All right, and I believe we also need to address parenting time while we're waiting on medical records. Ms. Tucker, what's the agency's desire in this case?
As is pretty common practice, given that this is a termination petition and that there were physical injuries to the child, and Dr. Moore's opinion on this case, with the information we know so far, the agency would request suspended parenting time, Your Honor.
And the child who is alleged to have been injured is which one?
Remington.
Remington. Mr. Kelly?
Your Honor, I believe at the last court hearing you ordered supervised parenting time. I thought by DHS or its designee, but your court order just simply said DHS. Children, is my understanding, they're with family or familiar relation. They're willing to supervise. My client indicates to me the placements indicated they're willing to supervise. I don't have any objection to having some of the visits at DHS so they can observe the interaction between mom, dad, and child. But we have children here, Your Honor, that are 3, just over 1, and essentially a newborn in Riley who's born in March. These children need to have time with their parents, especially Riley, to bond with mom and dad. So I would request that supervised visits continue by DHS and include the designee provision, Your Honor, so they can maximize the time with these very young children. I believe the placements are more than adequate to keep them safe. Thank you.
Ms. McCluskey, I'm assuming you'd make the same request?
Yes, Your Honor. I would second those comments and request. Thank you.
And Mr. Brown, are you supportive of parenting time?
Wholeheartedly. And these grandparents, and I'll be brief, I have utmost confidence in these grandparents who see the children all the time to supervise parenting time. And in fact, they requested that it not be at the agency because that puts a hardship on them. Unless the agency has some particular reason why they want to observe the parenting time, I don't see why all of them can't be at the grandparents. Again, I have utmost confidence in them. They're no nonsense, absolutely no nonsense whatsoever.
All right, I'm going to order supervised visits by the agency or its designee. I expect the visits to be frequent, particularly with the newborn. Parents need the opportunity to be able to bond with this newborn. And we'll see you back here in 2 weeks. That'll be May 11th at 8:30. Hopefully we'll know the scope of the medical records, and we will have an idea from Dr. Girton as to how soon he will be willing to issue a report or able to. Anything
Ms.
else
Tucker,
this morning?
I would just wonder if Ms. Tucker could email me so I can discuss this with the agency too. Who actually is the decision maker that's making the decision on this, so I can speak with them. So maybe we can save a little time.
Sure. I will email you the workers on the case as well as their supervisors.
I just want the decision maker.
He wants to Darth Vader.
I will do what I can.
Okay.
Okay, I think we're ready for some post terms now. First one is Prater children. Okay, we have a post-term hearing regarding Trenton and Daisy Prater. We've got Joy Jennings present. We now have a connection with Pamela Freeberg. And let's see, Ms. McCluskey is LGAL. I also see Mr. James Prater is present. Are we expecting anyone else this morning? Okay, Ms. McCluskey, how are Trenton and Daisy doing?
I reached out to both placements and did not get a response. Generally, Ms. Beck has responded. However, I've reviewed the report. I am in agreement with the recommendations. It's my understanding that Mr. Prater has some issues with myself as LGAL, so I'll just address those after he's able to put those on the record.
Okay, and Ms. Jennings or Ms. Freeberg, do either of you have anything to add to your report?
Yes, I do, Your Honor. I wanted to note that the placement change for Trenton was planned for April 16th, and we were unable to make that happen. Trenton refused to leave the home on the 16th, and again, when we tried on the 17th. I spent over 4 hours with Trenton and the families, really trying to motivate him and engage it to make it work, but we were unable to do it because he continued to refuse. Right now, we're kind of reassessing where we're at. The relatives were upset because Trenton was disrespectful. So now we're trying to assess kind of where we're going to move forward.
Right, and is Trenton still in this foster home that he doesn't want to leave?
Yes, that's correct.
And a foster home that's not willing to adopt?
We are unsure about that at this time. I don't know, Pamela, if you wanted to give any more insight into that portion.
I think at this time, the foster parents' feeling is that Trenton does have appropriate relatives, and their, first choice would be that he be allowed to be placed with relatives, if that's at all possible. If it's not possible, if the aunt and uncle decide that they would not adopt, I think it's something that the foster parents would consider, something they'd take into consideration. But they do definitely support him being with his relatives first.
So we've had two different relative homes now where Trenton has put the brakes on. I mean, we were working to try to get him to a point where he was willing to go to his uncle's home. I'm assuming that's you, Mr. Prater, isn't it?
Right.
All right. And now he's refusing to go to a different relative's home. I mean, how long are we going to continue to do this?
To provide insight on why we also tried so long to do the placement change, Dr. Henry had recommended we do extended lengths of visits with the relative, hoping that he would become more comfortable and used to being there, but we haven't made progress with that at this point.
Okay, and now Daisy has been moved into Mr. Prater's home. Is that correct?
Yes.
And
Placement orders were signed, and we do have a final adoption hearing scheduled for June 4th.
Oh, okay. And that seems to be going well, that placement?
Yes, definitely Mr. Prater has followed up on all resources for Daisy. He has found her some appropriate specialists for her emotional needs. She has started medication for ADHD, which I believe has helped somewhat as far as with her behaviors. I know that Mr. Prater's been appropriate in handling how her behaviors are, and there does seem to be some improvement since she has been home.
So, was there some thought by moving Daisy into Mr. Prater's home that might make it a more palatable destination for Trenton? I mean, was that part of the thought process there? Or does Daisy really need to be placed separately?
Mr. Prater has indicated that he's only able to take placement of one of them.
Okay. All right. Well,
if I can speak to that, Your Honor.
Yes, please. I got to adjust volume. I had trouble hearing both you and Ms. Freeberg. I'm going to turn my volume up at this end, although it'll probably make everyone else really loud. But go ahead, Mr. Prater.
So originally when the situation at my sister, who originally was selected for adoption, when that became untenable due to Daisy's behavior, we had a family meeting, and my sister Melissa, who has recently tried to adopt Melissa, we had talked about, we felt it was in the children's best interest to have Trenton go with Melissa and Daisy come to my house, so that each kid could have more one-on-one attention for their needs, specifically Daisy, because her behavior at times was out of control. And so that was why we made the decision. We felt like with Trenton having a cousin at his aunt who was the same age, that he might be more open to going there because it was closer to the Colligans. He could stay in contact with them, see them and visit them. It would help his transition in that sense, being a little bit closer to them and in a similar neighborhood. So that's where we originally discussed each of us, aunts and uncles, taking one of the children after the adoption of both the girls at Carrie's house didn't work. So I'm not opposed to trying to take Trenton. It's just there's going to be some more discussion involved. There'll have to be some more discussion involved on that.
And just to add to that too, Trenton has been expressing his bonds with his aunt and uncle, and his openness to moving to their home for adoption. So I think that that's where we all felt that he may be more inclined to want to move to their home rather than Mr. Prater's.
All right, so that at least presently that's the game plan, and hopefully get him to a point where he's willing to do some visits and see what his comfort level there is at Aunt's home. Okay, so it's frustrating that we've seen so many bumps in the road with Trenton in particular, but I'm pleased to hear that we're about to finalize in another little over a month with Daisy. So that's encouraging. So I'm going to set our next review. I'm sorry, Mr. Prater, was there anything else that you wanted to address?
Yeah, I did want to address the court about assigning a new LGAL due to the lack of involvement. And I wanted to address put it simply, the kids don't even know who the LGAL is. And she hasn't been involved. And I think given specifically moving forward for Trenton, that he's been in foster care for 50 months now, over 4 years, a fresh set of eyes and more involvement would be helpful for that situation. We requested that because we had complaints and concerns with the former foster care worker, Sharon Ernst, and DHS made the switch to Joy. And to her credit, she's been far more involved than Sharon has been. And I think we need everybody on that same page with Trenton. And from my family's perspective, we haven't seen that from Rebecca McCluskey. And I've sent her emails. I contacted her. I mean, this goes back several years of reaching out to her with concerns, specifically for Trenton. And she's been non-responsive and unaware of the situation. She didn't even know there was a complaint filed with the Office of Children's Ombudsman. She didn't know that there was a trauma assessment requested and that was ongoing for over a year. It was requested in December of 2019, and it didn't occur until late October, early November of 2020. So a lot of things that she wasn't aware of. So there's just concerns with her ability to speak on behalf of the children when she's not even involved or hasn't put forth the due diligence to understand the situation. So the comments like that, she reached out to us and we didn't respond back. She called yesterday, the day before the court meeting, which has been the pattern, from a restricted number during working hours. So my request of the court is just for a fresh set of eyes on the situation. Also, my concern with Trenton is he's been at the Colligans for, I believe, over 3 years now. And they've been good to him and he's comfortable there. And that's part of the reason why he doesn't want to leave, which is no fault of their own. But I do think if he's not going to be adopted by them, it's unhealthy for him to stay there for longer. And there hasn't been, in my opinion, there hasn't been any progress in almost 1.5 years since I originally tried to adopt him. He would agree to come and stay. He's happy to come stay a night or two on the weekend, but he was refusing to move at all or to take any steps towards movement. And that pattern continued when we tried to have him placed with his Aunt Melissa, my sister. So there really has been very little progress in that sense in 1.5 years. I think at some point somebody has to step in and say enough is enough. He's been in foster care for 4 years. We have people willing to adopt him, but nobody's willing to take him out of that home. And from my perspective and my sister's perspective, it would be even worse for us to try to physically remove him from that home against his will. Even worse for our relationship. So we were hoping for somebody to step in from the state side. So in that sense, I think a fresh set of eyes would be helpful, especially considering, Rebecca McCluskey, I believe, has a personal relationship with the college. Her involvement with Trenton, to where she relies more on the foster parents' input than actually speaking to the children themselves. Like I said, I don't request this lightly, but the children don't even know who she is. They haven't seen her. She's never been to my past residence in Jackson or my new residence. And as far as I've been involved with the kids, I don't believe she's seen them at all. She hasn't participated in many of the family team meetings. So we're just asking for somebody that will provide more involvement. It's nothing personal. It's just, I think there's 4 years in, there should be a standard of care and involvement for these kids. And we haven't seen that.
So, Mr. Prater, before I give Ms. McCluskey an opportunity to respond, I did want to address the other subject that you raised, which was Trenton's unwillingness to leave the foster parents' home. Are you suggesting that you think DHS should physically remove him from that home against his will and place him in your sister's home?
I think something needs to be done, but I don't think it should be the people that are trying to adopt him because he's just going to be resentful of them. I think it should, to be honest, it should be somebody that would have a short-term relationship with him, where he. So yes, if it was DHS, I mean, ideally, the Colligans would be able to talk to him and let him know that, he can no longer stay there. And I know there'll have to be therapy involved with that. But he knows, and we've talked to him over and over, that he's still going to have a relationship with them. He understands the situation. He just doesn't want to allow it to happen. He knows that the Colligans are still going to be a part of his life. We're friends with them. They've offered to still have him over. We're willing to do really any type of transition needed to where he can still see them. And even at my sister Melissa's, which she's on a field trip with her daughter at school. So I believe that's why she wasn't able to attend the hearing today. But Melissa feels the same way I do as far as still having Trenton be involved with Colligans and providing, visits with them and whatever necessary for his transition. I think he understands that. He just, he knows that nobody's going to make him move if he puts his foot down. And I personally feel that has to come from his custodians. I don't think somebody that is trying to adopt him should be the one to remove him from the place that he wants to stay at the moment.
All right, thank you. Ms. McCluskey?
Thank you, Your Honor. So as the court's probably aware, Mr. Prater very recently became involved in this case. That obviously the goal from the day I took over this file from Ms. Dungan was reunification. And as the court is aware, parents took some time. We were very close to reunification and they all went sideways. So this case went on for a little bit to begin with. I do not appreciate the complete misrepresentations Mr. Prater's made. I have spent more time on this file than any other file since I took this contract almost 4 years ago. Those children would not be in the care of their family if I had not advocated post-termination for the girls' removal from a foster home that I thought was abusive. And I do believe that MCI or MIC or MIC got involved after the fact and determined that there was abuse going on. Before COVID hit, I met with these children in their placements homes for their convenience every single review period. Mr. Prater, I don't think understands that we're required to contact or see the children before COVID, before each review. I'm not required to have contact weekly, although I did. I probably have 4,000 emails from everyone on this file because there was so much going on behind the scenes because of just the circumstances, Daisy's behaviors, the post-termination move, which I still have never seen. I certainly never advocated for something like that prior to this case. And I haven't seen any other LGAL do that because it's so much easier to leave children in that placement. Those girls had been with that placement for around 2 years. The agency was not on board with that. And then again, because of my advocation for that move, it happened. I met with Mr. Prater and his sisters. I'm sorry, Miss Peru, Miss Beck was out of state at the time when I first got this file. I invited them into my office. I met with them. I listened for probably 2 hours, all their complaints about what had happened with this case. what the agency had done, what the agency hadn't done, all of the blaming. But at the end of the day, those two family members asked for those children to be removed from their home at the beginning of this case. And I understand that there were some issues and the agency was not supporting, especially Ms. Peru, the way she needed to be financially supported. She was a single mother at the time. So again, these children wouldn't be with this family if it had not been for me, because they certainly were not involved during this whole case. I was copied on emails from Mr. Prater. He's never reached out to me directly. I was only in email chains, and it was about a CTAC, but as the court is probably aware, Trenton had not one behavior before he found out that the appeal was unsuccessful. So this was very recent. It's not my job to set up the CTAC. I'm sure I was advocating for it. If it was happening, I talked to Ms. Ernst so often about this case. And again, yeah, I haven't seen the children in person or visited them since COVID hit, and nor have I done any home visits, but I still during COVID would contact these placements before every hearing. I attempted to talk to Trenton during COVID, but as he behaved with his counselor, he didn't want to talk to me on the phone. So of course I got a lot of information from Ms. Colligan, as we're all doing right now. I'm not setting foot in a house for my own family's protection during COVID. We've all done whatever we can to still comply with our statutory requirements, but keep everyone safe as we're required to. I probably, there have been so many FTMs. I think Ms. Freeberg can attest to this. I may have missed 10% of them because I have a private practice and I have 2 contracts, and we just can't make these happen sometimes. There were probably 12 people involved in these FTMs, but I made every single one that I could. I have been more involved in this file than any other file I've had, and anyone other than Mr. Prater can confirm that. I personally visited Daisy and Anna Ray. Daisy recognized me every time. She knows who I am. Trenton, I've been in his house. The girls know who I am. I personally donated bicycles, clothing, toys to Daisy and Anna Ray. I'm not sure if Mr. Prater knows that from my own daughter. I have gone above and beyond in this file. His recent involvement has no bearing on my extreme involvement for I believe I got this file in August of 2017. And I have gone above and beyond the duties. I just don't know that Mr. Prater understands what my role is, because I don't have the ability to actually set up these services. Those are the responsibilities of the agency's workers. It's my job to advocate and to light a fire under any individual that's not doing their job and getting those services set up. And that's exactly what I have done. I will also note, if Mr. Prater hasn't reached out to me, which he has not, Ms. Peru would on behalf of the girls if there was an issue, and I would be on top of it, addressing it and contacting the agency, doing everything I could. Mr. Prater's never done that. We as LGALs, we're not on the front lines as the agency's staff are. If there's a problem, we don't know unless it's brought to our attention by placement or by an agency worker. As for a personal relationship with a Colligan, that's only because of all of my contact because of Trenton. I don't have a personal relationship with them, nor did I even know them before this placement. So that is a ridiculous statement as well. I've reached out to Mr. Prater, and I apologize. I do want to clarify one thing. When I called each placement this reporting period, it was not Ms. Colligan, because I was under the impression that Trenton had moved on that date he was supposed to have moved on. And I was not made aware that he didn't. So I did reach out to Ms. Colligan. She always responds. And again, as for the trauma assessment, I would have advocated for that as well, but there were no behaviors at that time. I think that's probably why Ms. Ernst, I don't know if she took time. Obviously, we all know that there is sometimes a delay with service providers, getting children in, coordinating schedules. So I can't speak to what was going on at that beginning point, but I think this court is aware. And I'll say Trisha as well. I visited Trisha in her placement home, as I do with a lot of my children. I don't inconvenience these placements further and make them come to my office. I want to see their homes. That is my regular practice before COVID. and any one of my placements can confirm that. So as for this complete misrepresentation that I have not been involved, I've been more involved than really any LGAL I've seen in any case. So,
Your Honor, she's actually committed, this is the second time she committed perjury and lied about my involvement. I have multiple emails directly to her. Mrs. McCluskey actually responded to my initial email back in November of 2019 and said that she would follow up with me. She never did. I have those emails as proof. So this is the second time that she's lied about.
All right, I'm gonna bring this to a close. I have zero reservations about Ms. McCluskey's advocacy for these children. I appreciate that your perspective is different, Mr. Prater. I've listened to what you had to say. I have no concerns here. I have no intention of replacing Ms. McCluskey. I think it would be a disservice to the children to put somebody else on this file at this point. So did I give you, okay. Our next review hearing is going to be July 20th at 8:45. Thank you.
thank you, Your Honor.
Thank you, Your Honor.
Okay, next up is Hayden Joyner. Well, I don't know what happened to Ms. Watson. I thought she was in the hearing. I let her in previously. I don't see her in the waiting room. Let's see who else is on this one. Maria Kleckner. There she is. Good morning, Ms. Kleckner. I just called the case of Hayden Joyner. My notes indicate that Shauna Watson is the foster care worker, and I thought I saw her present earlier this morning. I don't see her now.
Actually, Your Honor, there's no foster care worker assigned to his case anymore because he's in adoptive placement.
Oh, okay. Well, that would explain why she's not here.
No, it's
Thank
just
you.
me. Good morning.
Good morning. And let's see, our Mr. Williams is not here. Well, we better get a hold of him. Let me see if I can track him down.
And Your Honor, I actually, I called the Supreme Court's office and no appeal has been made to the Michigan Supreme Court. So yesterday I submitted a new report on appeals and rehearings. And so we can go ahead and uh, sign the order of adoption.
All right, I just shot Mr. Williams an email. I really need him to be present for this. I'm going to go to the next case. We'll just keep you in the meeting room until I hear back from Mr. Williams.
Okay, no problem.
Okay, next up is Rhythm Grayson. Let's see, Mr. Kelly's here. Let's see, we've got Ms. Scott. And I don't see her. And let's see, Nicole Trevor. There she is. Okay, this is a matter of Rhythm Grayson, Mr. Kelly's LGAL. Nicole Traver is here on behalf of the agency. Mr. Kelly, how's Rhythm doing?
Your Honor, I'd spoken with placement. If you recall, this just recently came post-term matter, so I'd spoken with placement within the last 30 days. Rhythm was doing well at the time. I suspect that's not changed at all. I reviewed the report. I'm in agreement with the ultimate goal of adoption.
And Ms. Traver, do you have anything to add to your report?
No, Your Honor.
All right, your report indicates that Leanna Scott has been assigned as the adoption worker. I don't see her in the waiting room this morning. Have you had any contact with her?
I believe she's on vacation.
Oh, okay. All right, well, Rhythm's doing fine from your perspective?
Yes, she actually just started walking this week.
Well, that's good to hear. So we're early in the process here. I see an expected date of achievement, October. I guess time will tell whether or not that's realistic, but given the early stage that we're at, it does appear reasonable. I'm going to implement the recommendations. We'll set our next review hearing for July 20th at 8:45. Thank you. And there's Mr. Williams. Good morning, Mr. Williams. We're here on the matter of Hayden Joyner, and Maria Kleckner's here on behalf of the agency. She informed me before you logged in that there have been no appeals filed with the Michigan Supreme Court. So the court is able to proceed with the adoption. I'm going, anything else that you needed to report, Ms. Kleckner?
Nothing further.
Mr. Williams, how's Hayden doing?
Well, Your Honor, Hayden's been in this placement forever, so he continues to do well. And I know that'll be a load off of both placement and Hayden to be able to proceed and finally finalize this adoption.
All right, well, I am going to set a next review hearing date just in case we run into any snags. July 20th at 8:45. Obviously, if the adoption's finalized before then, there's no need to appear. Thank you both.
Thank you.
Thank you. Sorry for my tardiness.
No problem. Okay, next up is Dominic Toll. Let's see, there's Mr. Lemble. There's Ms. Toll. I think that's probably everyone. Let's wait until we have a connection with Ms. Toll. Ms. Toll, you can hear me now?
Yeah, I can.
Mr. Lemble, can you hear me? Sir, if you did speak, I did not hear you. Check your settings.
Can you hear me?
I can now. Thank you, sir. Okay, so Ms. Tucker's here for the agency. Mr. Brown is LGAL. Ms. McCluskey represents mom. Mr. Hotchkiss represents dad, and both mom and dad are present. So, Mr. Brown, how's Dominic doing?
I spoke with placement. Dominic's doing very well, and he is transitioning back to both parents. I want to let Miss Carol know that I put both of my affidavits in the mail this morning, so I didn't get a hold of my one placement until yesterday. The issue, what's going on now, Judge, is that we're ready for the family reunification program. However, the family reunification program will only go into one home. It's my understanding that the parties are close to an agreement to share joint physical and joint legal custody of the minor child. In the past, we've had family reunifications go into two homes, but that was only because one parent lived in Calhoun County and one parent lived in Jackson County. So the court's going to have to make a decision as to what parent that family reunification program is going to go into. I have my thoughts, and if the court would like to hear them, I will put that towards the court. But that's the issue that the court's going to have to make today. Thank you.
Right, and I will want to hear that, but before I do that, let me ask you, from whose home was Dominic removed?
Mother.
All right, go ahead, Mr. Brown, with your recommendation for which home should benefit from the family.
Dominic was placed with his paternal grandparents, and from the beginning, I appreciate everything that Ms. Toll has done, but if the court remembers, from day one, I was concerned, even though mom has went through therapy, that she never was able to come clean as how these significant injuries to Dominic occurred. And they still haven't occurred to this day. And I told the court a year ago that I would never be comfortable returning to her home until there was some acknowledgement of what happened and own it. It hasn't been owned to this day. So with that in mind, I can only stick to my word that I said back then. And I would suggest that family reunification program be set forth in father's home. Thank you.
And Ms. Widener, is it correct that FRP will only go into one home, even though there are potentially two custodial homes involved here?
Correct. I have spoken to FRP and they only service the primary household that the child's returning home to, who has the child more than 50% of the time, which ultimately would mean that we would recommend that Dominic be returned to a home who has him for one extra day with the family reunification program in place.
And whichever home has the one extra day, you would support FRP there, regardless of which parent it is?
Correct.
Okay, well, let me hear from Ms. McCluskey then.
Thank you, Your Honor. So that I was unaware of this circumstance, so I wasn't able to discuss it with my client. So I would be, if she's comfortable, I would be comfortable with the court querying her on her thoughts on FRP. I know she's fully engaged in all services. She's benefited, so she would clearly benefit from those services. And I do believe that part of the file is not right in front of me, but Dominic was with her primarily. So I think, you know, if it came down to a one extra day circumstance, that definitely should be her receiving that benefit. But again, if the court
All right. Before I hear anything further, I just noticed that Mr. Hotchkiss isn't present anymore. And he did alert me this morning that he had a 10 o'clock hearing in another court. So my apologies to everyone. I'm going to put this one on hold until Mr. Hotchkiss is able to get back in here. And we'll need to repeat what's already been stated to bring him up to speed. Oh, here he is. So, Mr. Hotchkiss, my apologies. I failed to notice that you had departed the hearing. To bring you up to speed, we're on the matter of Dominic Toll. The agency is recommending return home with FRP services. The challenge is that FRP will only work with one custodial home. What the parties apparently had been discussing is a joint physical custody, but FRP will only go into a home that has primary physical custody, which Ms. Widener indicated would be if one parent had one more day per week than the other, that FRP would view that as a custodial home and would go in and service that home. So where we're at is whether or not the parents have any flexibility on that issue. Mr. Brown advocated pretty strongly that he thinks the custodial home ought to be Mr. Lemble's home because of concerns he's got with mother never having acknowledged what it is that caused the injuries to Dominic. So I've asked Ms. McCluskey what her view on the custodial arrangement is. She simply deferred to her client because she simply hadn't heard about this issue until this morning. So have you heard about this issue before this morning?
I have, Your Honor. Your Honor, I have heard about it. In fact, Mr. Lemble had filed a motion regarding custody. It was scheduled yesterday for an evidentiary hearing in front of Judge Wilson. As I understand it, mom is represented by Mr. Navarre. Mr. Lemble in that matter is represented by Matt in our office. The two of them came to an agreement with respect to custody. Frankly, it was a joint physical custody arrangement that they had agreed to. And it was based on the premise that the agency had felt that mom had participated in whatever services she deemed necessary or that the agency deemed necessary to rectify the situation that brought this case into care. But I will tell you, I agree with Mr. Brown. I have had concerns, as has Mr. Lemble, about those issues. But it's the agency who's been, I don't want to say dismissive, but they don't seem to be as concerned about what's occurred as what my client has. But they had agreed to an arrangement. It looked like, from my client's perspective, it looked like to be the best resolution possible. Now, Matt from our office, I think, spoke with the caseworker and was informed to believe that FRP would be involved with both homes as long as they had joint physical custody. But apparently that's not the case, and FRP must have weighed in and said no. But like I said, Mr. Navarre represents mom, but I don't think that my client, and he can jump all over me right here and speak up, but I don't think my client is going to want to relinquish anything other than 50-50 plus custody.
If I may make a suggestion, I don't know with Ms. Widener, one, whether the court can order families for FRP into both homes, or two, put families first in one home and FRP in one home. I think that would solve the problem.
Ms. Widener, is that, I don't think I can order FRP to do something that would violate their whatever grant they operate under, but using two different services, one in each home, sounds like at least a reasonable suggestion. What's your view of that, Ms. Widener?
Right. So I did actually reach out to Families First, and we kind of discussed that possibility where FRP would be in one home and Family First in the other. However, Families First, their opinion was that it would be difficult because the programs are intense and they'll be in the FRPs in the home 4 days a week. Well, 4 hours a week, but it'd be like a four-day week program for them. So I don't know if it would I don't know if it could possibly work. However, I can discuss that with the family reunification program and see what their thoughts are. But from my understanding is that they would only work with the family who's the primary household. So I don't know if they have two primary households.
Well, and I understand that that's the objection that FRP has indicated. Does Families First operate under the same restriction? In other words, are they willing to go into both homes?
When I spoke to them, if it is 50-50, there is a possibility that they would be able to go into both homes. However, it would just be difficult with the parents only having 50% of the time with the child. I can reach out again to discuss that matter. I would like to see both parents in a reunification program. I think they've both done very well in that they would benefit from these services.
All right, so I think that's probably what needs to be explored then. Let's see if Families First is willing to go into both homes. The fact that they think it'll be challenging, I get that. It probably will be. But at least if they're willing to do it, that seems to me that solves our problem.
Your Honor, I just received an email from Dana Sprague regarding this case. I don't know if she'll pop into the waiting room or not, but she said that they have spoken with FRP and Families First at length. FRP cannot work with a family unless they have the child for more than 50% of the time, and Families First will only work with the primary household. So that seems to be kind of the policies that both work on, or under, I should say.
Which wouldn't surprise me. It's probably a requirement of whatever grant funding that they operate under. which leaves us with a significant dilemma here. We want to return, we want to reunify with both parents. The fact that we have parents with shared custody is commonplace. And even though we haven't encountered this particular issue in the past, it just is, I guess, quite surprising to me that there isn't some mechanism in place to reunify with two parents in separate households. What I can do today is include in my order that the agency has discretion to reunify with both parents and leave it to the agency to figure out what kind of services they're going to be able to get into each home to make sure these are both successful reunifications. So that's what I'm going to do. We'll set another review hearing for July 27th at 8:45, but I would certainly consider earlier termination if reunification and whatever services we're able to obtain are completed successfully. And I see Ms. Sprague just logged in, so I'm going to hear from her before I close out the file.
Thank you, Your Honor.
So, Ms. Sprague, I saw that you had just logged in. I don't know if you were able to hear with the live stream where I'm headed with this, but I wanted to give you a chance to speak up.
Hi, Your Honor. Yes, I think you said it really well that it does put us in a hard place. We have talked with, Tara and I have talked several times, and we've had many discussions with Samantha and Devin as well, that it feels like we're having to choose which parent is the better one, and that's not what we're trying to do at all. We would like both of these parents to be serviced as a return home, but like you said, our policies and the way that the funding works for these programs don't allow us to do equal. So that is the dilemma that we're in. If you proceed with giving us discretion to return home and making that decision between FRP and families, that would be helpful. But we have had discussions with them at length with FRP and Families First, trying to see how we can get it to be as equal as possible. So that's our goal too. That's what we want as well.
All right, so what I'll provide in the order is that you have discretion to return home with in-home services. I won't specify which program, and let's see what you can work out. I'd hate to delay a return home over something like this, but on the other hand, we need to make sure that the reunification is successful.
Thank you, Your Honor.
So I will set a review hearing for July 27th at 8:45. And if you're ready to close before then, just let us know. And if there's no objection, we might be able to just close it administratively without a hearing. Thank you.
Thank you, Your Honor.
Thank you.
Mr. Hotchkiss?
Okay. Next up is the Cox miners. So let me let the parents in. And let's see. And there's Ms. Hines. I think that's everyone. And let's see. Let's make sure I've got a connection with everyone. Ms. Curry, can you hear me?
Yes, I can. Can you hear me?
I can. Mr. Cox?
Yes.
Okay, and we've got Ms. Hines for the agency. Let's see. Ms. McCluskey is LGAL, and Mr. Brown represents Dad. Okay, so let me hear from Ms. McCluskey first. How are the two children doing?
I actually tried several times and again this morning to get a hold of Miss Curry, but I keep getting a busy signal. So I would just ask her if her number has changed or anything of that sort, just to please let me know. She does reach out frequently. I've had quite a bit of contact with her, so I've obviously no concerns with the children in her care. I was a little concerned with the reference to the CPS investigation in the court report and the reasons for that. But ultimately, CPS did not substantiate. So I would just note that. I see that the agency's requesting a custody order. I would support that at this time based on, specifically because the custody order proposed would give Mr. Cox some supervised parenting time, which I think would be appropriate. But based on Michael's issues and Dr. Henry's note in the CTAC report, specifically that Mr. Cox is unlikely to be able to admit any wrongdoing or really take responsibility for his role in the maltreatment, especially of Michael, in any time less than a year is kind of concerning. So for those reasons, I would support a custody order being put in place. Thank you.
So I share Ms. McCluskey's concern with the new CPS complaint. So even though it was not substantiated, sometimes I wonder what exactly that means. That we found these circumstances to exist, but determined that they don't constitute neglect or abuse, or we didn't find these circumstances to exist. Seems to me it would be very hard to substantiate that the circumstance didn't exist given the involvement of people at school and independent verification that Michael wasn't in a fit condition to be in school and shouldn't have been sent to school that way. Ms. Hines, are you able to elaborate at all?
Yes, Your Honor. In speaking with the investigator and reviewing that investigation, there was not evidence to support those allegations. He was not observed to have black eyes. He was not observed to be dirty. So the discrepancy between the allegations and the investigation, there just wasn't any evidence to support that. So that's why it was not substantiated.
Okay, thank you. I appreciate that. So the recommendation is that we reunify, well, I guess they're already with mom, but that we close this case upon entry of a custody order. And that's still your recommendation?
Yes, Your Honor.
Mr. Brown, do you wish to be heard?
Yes, all I can say is Mr. Cox has engaged with Ms. Hines in every service and did every service that he was asked to do. The only issue that keeps on coming up is that he doesn't see the significance of the corporal punishment that he used with Michael. And I have said repeatedly, and he said to this court repeatedly, that he does. And there's an issue with housing. I'm not going to disagree that a custody order, this court can enter it without my approval, but to say that he should only get supervised parenting time after going through all of these services for an infinite period of time, I don't think is proper. He should not have to have supervised parenting time if he can have a safe, stable environment for the children. The issues with mother, were the teachers lying when they observed these situations with Michael? That's hard for me to believe. So I would ask that the court, if the court's going to enter a custody order, that there be an appropriate amount of unsupervised parenting time for Mr. Cox.
All right. I'm inclined to implement the agency's recommendation. Mr. Cox certainly will have the ability both to object to a temporary ex parte custody order and also at any time in the future, particularly when he has housing, to petition for a more specific parenting time order. And that's something the court will look at based on the facts that exist at the time. But I'm not going to keep this neglect case open for resolution of that issue. So I will see that an appropriate custody order gets entered. As soon as it is, the matter will be dismissed as a neglect case, and any future discussion of the extent of Mr. Cox's parenting time will take place in the context of a custody hearing. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Morning, Peter. And let's see, Wyoming Westman. When I call the case where the dad's in jail, would you remind me of which one that is?
Gibson.
Gibson? Okay.
I didn't know he was in jail, so I didn't request him.
Well, right, I knew that.
Oh, okay.
I was going to see if he's at Channer Road, if they would still bring him to the.
Gotcha, I got you.
I'll just call over there and see like we do across the street or across the alley.
And we're just
Okay,
closing the case, so I don't really, if we're just closing the case, I don't know if I want you to go through the effort of having him.
All right, I'll keep that in mind. We'll call that one. I want to do Wireman Westman first.
Okay.
Let me get everybody on board with this one. So we've got Ms. Johnson. I don't see any parents here.
Mom was here, Miss McKay, earlier this morning, smoking a cigarette.
All right, she is here. I don't see either father.
For the court's
So
information, I called Mr. Wireman yesterday and left him a voicemail. That was early in the day, and he never returned my call. And looking at my voicemail now, there's nothing there. So I don't think he ever actually called me back.
Okay, so Wireman and Westman.
Mr. Westman may be here under Alicia Wallace.
Oh, okay. I have an
That phone?
Alicia.
Okay.
I will let Alicia in. You said that was Mr. Westman or Mr. Wireman?
Westman. Westman.
Okay.
Hello.
Mr. Westman, can you hear me?
Yes, I can.
And then also, I believe the foster parents were going to try to be present. Oberlin, Debbie, or Larry Oberman. Oberlin, sorry.
I've got a Debbie, but it's Debbie Potter.
Okay.
And I've got a first name of a Cassandra. I don't have a last name. That wouldn't be anyone connected with the foster parents.
No, ma'am. No, sir.
Okay, so
They told me they were going to watch on YouTube.
Oh, okay.
okay, and it's running, so they should be able to see that. Okay, so we've got Ms. Tucker for the agency. Mr. Brown is LGAL. Mr. Hotchkiss represents Mr. Westman. Mr. Kelly represents Mr. Wireman. And Ms. McCluskey represents Mom. We also have the mother, Ms. McKay present, and we have Mr. Westman present. So, Mr. Brown, how are Peyton and Nakia doing?
Well, as always, Miss Oberlin, I think goes above and beyond considering the medical needs of Peyton. Both foster parents are certified for high risk medical individuals. Just luckily, Miss McKay's aunt is certified, so she could have placement of the children. They're doing very well, and I have no concerns with regard to the children's well-being. With regard to Mr. Wireman, we were notified earlier today that he is potentially a putative father to another child. I don't know, in my opinion, I don't think this has anything to do with this case, but I'm in support of the plan and ask the court to adopt it. Thank you.
So, Ms. Johnson, these children have been in care for a substantial period of time. It looks like we're about to hit the 2-year anniversary in another month. Where do you see this thing heading?
Your Honor, I just wanted to reiterate that this is a case I mentioned earlier where Ms. Johnson does have some information regarding one of the fathers that she has to be court ordered to disclose.
Okay, Ms. Johnson, I am ordering you to disclose that information.
Mr. Wireman continues not to make any progress and not to follow through with service. He has gotten involved in another case where he's the putative father. He believes himself to be the biological father, but the mother is married, and so there's another legal father. A couple things have happened in that case that I'm concerned about. There have been several domestic violence issues with that mother. They've kind of increased in severity to the point where he was allowed at the hospital following the birth of the baby. Security took him out because he was making physical threats to the mom at that time. I mean, right after she delivered. He then does not have any visitation rights with that child, and because of the domestic violence towards the mom, she had to agree not to allow him around herself or the children. He's been texting her, asking for visits, offering drugs if she'll let him see the baby. When that didn't work, he texted her a picture of a gun. And it just a concern towards women and towards the mother of his children. We're very concerned about that, and we want to leave his visits as supervised. I do also need to correct something from a report in July. In July, Miss McKay was stopped by a police officer. There were drugs found in her car. She was tested. She had passengers in the car as well. She was tested and tested clean. I talked to the police officer who told me she was not going to be charged. And so we, because he didn't feel the drugs were hers, she had been clean. We also increased testing at the time she remained clean. However, somehow they did charge her without telling us, and there was a hearing in January and a hearing again last month. So I just need to clarify that there is some police or some involvement there.
So charges were brought against her because of the drugs found in her vehicle when she was stopped in July?
Yes.
Correct.
Yes.
Okay, thank you for that update. Mr. Hotchkiss, do you have a position on the recommendations?
Honor, with respect to Mr. Westman, as the court can see, he's doing very well. The agency is recommending reunification and placement in his home. My client's excited about that, looks forward to that, and would ask that the court adopt that recommendation of the agency. Thank you.
Thank you. And Ms. McCluskey, are you in support of the recommendations?
We are, Your Honor, and my client does understand the agency is asking for full compliance this next reporting period. We don't have any doubt that that will happen, especially based on the most recent reporting periods. So no objection. Thank you.
Thank you. And Mr. Kelly?
Your Honor, as indicated to the court earlier, I've read Mr. Wireman at the number that was provided in the report seemed to be a more updated number than the one I originally had for him. It sounded like him as far as the outgoing voicemail message was concerned. I left him a voicemail and he has not returned the call, so I'd have no comment on the recommendations of the report. Thank you.
Thank you. I believe the recommendations to be appropriate. I'm going to implement them. We'll set our next review hearing for July 27 at 8:45. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Okay, next up is Christian Gibson. I'm listing Ms. Galamali, but she's not present.
It's Debbie Potter, Your Honor.
Oh, okay.
Miss
We'll let
Galamali is
her
the
in.
one that submitted the report, so I accidentally put her name.
Okay, we'll let her in. And let's see. Mr. Gibson, we were informed, was incarcerated, is incarcerated. And let's see, we've got Courtney Whitney, who I just let in. All right, looks like everyone's here. Ms. Whitney, can you hear me?
I can. Can you hear me?
Yes.
All right.
Okay, so this is a matter of Christian Gibson. Ms. McCluskey is our LGAL. Ms. Tucker represents the agency. Mr. Brown represents Dad. Mr. Kelly represents Mom, and Mom is present, and Ms. Debbie Potter is present for the agency. Mr. Brown, you'd indicated that you didn't think there was a need to involve your client from the jail since the agency is recommending case closure. Your client obviously is not in a position to take any kind of custody since he's incarcerated. Ms. McCluskey, how's Christian, and are you in support of case closure?
I wasn't able to reach Miss Whitney last week when I had tried, and then I did leave her a message only recently, so I didn't give her a lot of time to call me back once I could get through. There's a full voicemail box. But I've read the report. I don't have any concerns with Christian, obviously being with his mother. She's clearly doing very well. Only issues with the random drug screens, but that seemed to be a scheduling or transportation issue, which was eventually resolved. So I am in support of case closure.
Your Honor.
And there already is an existing custody order that gives mom sole legal and physical custody and limits dad to supervised parenting time.
Yes. I don't know if like the CPS order like trumps our custody order, but they were supervised visitation. Shane had, I have full legal and physical custody. He has supervised visitation, but I don't know if the CPS order or anything like trumps what the custody order has in place.
It does while this case is open, but if I close the case today, it'll revert to the custody order.
Okay, I know that last time we went to court, his parenting time was suspended until all court issues and matters were resolved, which those are continuing, ongoing all the time. So I guess even with the CPS case open or closed, his supervised visitation is suspended because of his open cases and warrants and everything going on with this court. So.
Thank you. Ms. Tucker, I think you wanted to say something.
Yes, Your Honor. I've exchanged a few emails with Ms. Potter this morning. My understanding is she wanted to address CPS's position on the record. And so I think it just makes sense to hear from her before we get too far into everyone else's thoughts.
Fair enough. Go ahead, Ms. Potter.
Thank you. Good morning, everyone. Your Honor, in the last couple weeks, Ms. Whitney did screen positive or admitted that she had used substances. First of all, I want to commend her for being open and honest and willing to admit that. We don't have a screen back yet. We don't have that screen back as of yet. It says it's in process. So because of that, the agency really considering that it may not be best to close right now and leave her without support. And maybe we could ask even for an early review hearing, like in 45 days, just to give her the extra support to continue with the drug screens to make sure that to be able to have her finish out FTBS and have them close, and for us to be able to have contact with her therapist just to make sure that she's doing well. We don't want to set her up for failure. I commend Courtney. She's doing well. I just feel like with the one screen and with her admitting that she was using, I just want to make sure that she's safe before we close, and ultimately that Christian will be safe too.
So, Ms. Whitney, would you like to comment on that?
No, I mean, I did admit to the use when the caseworker that was in place for Debbie when she was gone. But I'm still continuing my therapy and my family first with Amber. And I'm doing a follow-up with the person from, was that Highlands? She comes in and she does a, update and stuff like that. And we're meeting this week. But I'm continuing to do my therapy, and Christian starting his. I've done everything that I need to do. I had a hiccup or whatever, but I've been trying and staying on path and doing what I need to do for, me and Christian.
Well, in light of this, I think it probably does make sense that we keep some supervision in place. I could set an early review hearing just to make sure things don't go south. I think that's in everybody's interest to make sure that mom gets all the support that she needs. I realize that issues with drugs don't disappear overnight, but there's clearly recognition here, acknowledgement. That's very positive. So I'm encouraged. I think maybe let's bring this back in 6 weeks and let's see where we are. There haven't been any other hiccups, that everything else is going smoothly, that I would be able to order case closure at that point. Anyone else wish to be heard on this approach?
No, Your Honor.
Your Honor, I would indicate that she has owned what had occurred, and it sounds like she has all the services in place and is being proactive. It sounds like the services would continue even if the court was not involved. We're not getting from her that when she pays out, I'm done with those things. Instead, she's proactively addressing her sobriety, and it sounds like that will continue even without the court's involvement. So I would still support case closure at this time as opposed to us having another review hearing in 45 days. Thank you.
All right. And I appreciate that, Mr. Kelly. I believe that mom is on a good path. And I want to believe that her ventures into the drug world are over, but I just want to make sure she has every support possible to make sure that she stays clean. So Shannon, 6 weeks from now will be
June 8th at 8:45.
June 8th at 8:45. I hope all goes well, and I will be able to close on that date. We'll just continue the previous services. Highfields is in the home right now.
FTBS through Highfields.
Oh, okay. All right. We'll hopefully be able to dismiss in 6 weeks. I wish you well, Ms. Whitney.
You too. Thank you.
Thank you, Your Honor.
I'm going to take just